All right, good morning, everybody. If you're just joining me for the first time, my name is Mike Rafi, and this is my webinar. In my webinar, I pretty much do whatever I want to do, but my goal is to educate, inspire, talk, and hopefully entertain to some degree about legal topics that I think are important to me and should be important to anyone who practices personal injury law. This is my last webinar of 2021. I started doing these back in COVID, like real COVID, like everyone was sitting at home completely COVID. I started these because, well, first I was bored. And second, I wanted to share some information, get to know some new people. So I decided these webinars might be a good idea. Back in 2020, after 17 webinars and 17 straight weeks, I moved these to monthly webinars. So this is our last installment of 2021, and we're going to cover a topic which, while very, very important, is difficult to talk about. We're going to talk about wrongful death cases and how to handle those cases. And those cases can't be separated from our personal emotions and the fact that we are representing and helping people in the worst times of their lives. So I'm not going to belabor this point because it's pretty obvious. When someone has passed away, their loved ones are upset. They're hurting and they need help. But I do want to spend 1 or 2 minutes here just at least reminding everybody, and I'll do something similar to this at the end of the webinar. I want to remind everybody, and in fact, I even want to remind myself that what we do, although it's our day-to-day jobs, we generally don't want repeat customers. Because that means people are being injured or hurt over and over and over. In wrongful death cases, you are helping a family in what may be their worst moment in their lives. Their son, daughter, husband, wife, child, grandson, parent, whoever it is, has been killed, and they are trying to right a wrong or find out if there even was a wrong. So when you get calls for wrongful death cases, I think it's worth repeating and remembering that this is not, that call is not that person or that family's day-to-day activities like it is for us. That family doesn't talk to injured people. They don't go through personal injury cases, and they don't deal with injuries like we do on a daily basis. So as you're doing an intake, that I encourage you to do this for every intake, but especially in personal injury cases that involve wrongful death. My recommendation is to stop, to listen. Don't rush these folks. If you know you have an appointment at 1 in the afternoon, don't schedule a wrongful death consultation at 11 a.m. You don't want to be the person that says, "I'm sorry, I have to be somewhere else," during a whole family meeting where they're telling you about their loved one and what happened to them. So make sure you listen, and more so than any other intake, listening to the family and how they feel is going to be cathartic for them, and it's going to help them even if you can't take their case. Because if you treat people, and I guess this goes to marketing a little bit, but generally it's just humanity. If you treat people, especially families of people who have been lost, if you treat them well, if you show them compassion, if you care about them, and that comes through, and usually that comes through just by listening and asking questions about the person, about their family, that is going to make a huge difference because they're going to trust you. They're going to know you're not there just to make a buck off of them. I mean, that's the gripe on personal injury lawyers, right? We'll do anything to make $1. Well, go into that family meeting when you have it as someone with the perspective that you're just going to be someone who's going to listen to them and try your best to guide them on the right path. Because out of anyone that we run across in our day-to-day intake, our day-to-day prospective customer, prospective client conversations, wrongful death cases are the ones where we can make the biggest impact, even if there's not a case. Because if you listen to that family, you hear their story, and even if you know in the first minute that it's not a case, you sit there for as long as you can, you help them, you make them feel good because that's what they need. And at the end of the day, they're going to think to themselves, wow, Joe Smo, he's a great person. I felt so at ease for them. And even though there's not a case, that person cared about me and my family. And those are the things that people will remember. So forgive my part, or forgive my introduction here, not being extremely uplifting, but in a way, I hope it is. I hope that you take the responsibility that you have doing these kind of intakes and handling these kind of cases very seriously. And don't forget that we represent people. We represent families. We represent people who cry, who bleed, who get sad and happy. So remember that, especially in the wrongful death context. The number one question I get asked when lawyers call me for a wrongful death case, when a family calls me together, is who the heck can bring the lawsuit? What kind of lawsuits are there? So I'm going to give a quick primer here, and then we'll go deeper into some of these issues. The first thing is that there's two claims. There's the estate claim and the wrongful death claim. So when someone passes away, you can have an estate claim and you can have a wrongful death claim brought for their death. The estate claim is brought by the estate. There has to be an estate set up, and there has to be a personal representative appointed to that estate. Executor, administrator, whatever word you want to use, I use personal representative. In the estate claim, you are able to get damages for things that essentially happened in the past. So you're able to get damages for the medical bills, if there were any before the death, the funeral costs, the burial costs. And maybe the most important one is conscious pain and suffering. And we'll circle back to this when I get to the damages component. But conscious pain and suffering, meaning from the time the person got injured by whoever did this to them, negligently, wrongfully, until the death, that period of time, the conscious pain and suffering, highlight that one and remember that for now. We're going to come back to that. The second claim is the wrongful death claim, and that is brought by the surviving heirs. We'll talk about who they are in just a moment. But that claim I want you to think about is forward looking. It is the life and the value of the life and the value that that person would have brought in the future that's no longer going to happen. The most common element is the value of the person's life. Here in Georgia, that is through the eyes of the person who was killed. It's the full value of the decedent, the full value of the person who's lost, the full value of their life through their eyes, what they valued their life at. Other states, it's different. Other states, it's Colorado, for example, it's the value from the loved ones, what they lost, because it's actually their lawsuit, not the person passed away. So if you're practicing in other states, make sure that I would tell you probably that wrongful death damages is probably the thing that changes the most per state and how you're going to measure damages, especially in this context. That's what's different in most states. Or at least that's my take on it. So you have the two claims: estate claim, backwards facing; wrongful death claim, forward facing. You put them together, and in one lawsuit, you're going to have those two claims. It's really two lawsuits in one. You don't have to bring both. You do not have to bring both. Let's talk about the statute of limitations real quick. In Georgia, the statute of limitations for a personal injury case is generally 2 years. There's, of course, things that will toll or pause the statute of limitations. The newest one right now is what at least I call COVID tolling. There's 121 days of COVID tolling in the statute of limitations. And what that means is if your case happened on, I don't know, January 1st, 2019, you have until January 1st, 2021, plus 121 days. So you'd still have, you'd be out of time now, but you would have that extra 121 days. So maybe not the best example here. Other tolling provisions that are important in wrongful death cases, especially. If the person who died, if there's a criminal investigation about how the death happened, so it's a car crash and maybe the at-fault driver suspected of a DUI, or the at-fault driver was speeding or driving too fast for conditions, and therefore there's a small investigation period or maybe even a large one, and then there's a citation issued. Until that citation is resolved, until the criminal charges are resolved, or until the criminal investigation is over, the statute of limitations is tolled or paused. So I mentioned the car accident. One person's driving, hits another person, and they die. That driver who caused the crash is given a ticket for a DUI. That person pays the ticket. Let's say you can just pay that DUI ticket. That person, or that statute of limitations is delayed until the ticket is paid. If there's a criminal trial, the statute of limitations is tolled until the criminal trial is over. I handle a good amount of negligent security cases. These are cases where people are victims of violent crimes, and in a lot of our cases, people are killed, and we represent their family. A lot of shootings and stabbings that result in death. On these cases, the statute of limitations is tolled until the criminal investigation is over. Depending on the police force, it may be very easy to find out if the criminal investigation is still going on. In other jurisdictions, it's pretty difficult because there's this odd in between where, especially Fulton County, will say the criminal investigation is open, but it's not active. So be really careful about the criminal investigation tolling provision. Excuse me. But these are ways that you can extend the statute of limitations. These ways apply to tolling both the wrongful death claim and the estate claim. Now, the estate claim, though, has a separate tolling provision. It has a separate way that the statute can be tolled. And that is if there is not an estate set up. If there's not an estate set up, then the statute of limitations can be tolled for up to 5 years. So think of 2 train tracks. The wrongful death claim, you have 2 years plus whatever you can manage to toll. So you may have the traffic citation, COVID tolling, and then 2 years. On the estate claim, you might have tolling all the way until the estate is set up. All the way until the estate is set up. That can go up to 5 years, but let's just use the easy numbers with no tolling. On your wrongful death claim, you only have 2 years. On your estate claim, you have up to 5 years. So you may have tolling on your estate claim, but your wrongful death claim may be over. So just know in your head, it's really important to remember that you have different statute of limitations. You may have different statute of limitations for your 2 different claims. So focus on the shorter one, the wrongful death one, and make sure you file both actions by that time. This is similar to in the case of a minor, where the minor's claim for pain and suffering in a normal, regular old non-wrongful death claim, the minor's claim for pain and suffering does not start until the minor turns 18. But the parent's claim for the medical bills that the minor incurred and that the parents paid, that is subject to the 2-year statute of limitations. So hopefully that's at least a little bit of a primer here, and we'll give you some idea. The takeaway is you might have more time for the estate claim, but the wrongful death claim is usually the more valuable one, usually. So you want to make sure that you have both cases filed by the 2-year mark. And even if you don't have the estate claim or the estate set up, make sure you file that wrongful death claim. So who has to bring these cases? Let's start with the estate one, because that's frankly a little easier. The estate needs to be set up and created. And the person who is the personal representative, the executor, the executrix, the administrator, that person is going to be the one who has the right to bring the lawsuit. I want you to make sure that when you're helping a family set up an estate, I want you to make sure that you think about who the representative is going to be. That representative is going to be the person that is your plaintiff. So Sally Sue versus whoever. It's Sally Sue as administrator of whose ever estate. But Sally Sue is going to be the face. Sally Sue is going to be the face of your estate claim. So if Sally Sue isn't a good plaintiff, and what I mean by that is maybe she's not well educated, maybe she's a jerk, maybe she wouldn't present well to a jury, maybe she didn't have a good relationship with the person who died, maybe it's her brother, but they didn't speak in 20 years. She just happens to be the person that's doing the estate for some reason. Those are the things you want to consider, because you want the best person to be the face of your lawsuit. I was about to say business, the face of your business, and recently I've been thinking more about how personal injury cases are really mini businesses. I think the goal of a personal injury lawsuit is to make that lawsuit, as profitable as possible. And the way to do that is to treat it as an entity, increase the value through your legal work, through whatever you can do, and then you're eventually going to sell that business by settling it. Yeah, you want to come and buy this business? Come and buy it. If you can't sell it, what you do is you actually have an auction, right? You have an auction when you can't sell something, or if you want to see what the absolute top bid is, and that's what a trial is. So think of these claims as mini businesses that you're going to try to sell for somebody. And because that's all we can do as lawyers, we can sell their lawsuits either through a settlement or through a jury trial. So forgive that side note, but that is the wrongful death, or excuse me, that's the estate claim. You need a personal representative who's administrator of the estate, and that person then will have the right to bring the lawsuit. Then there is the wrongful death claim. I pause because I'm gonna make it a little dramatic here, because it is tricky and it is difficult. So here's how it goes. If the person who passed away, and I'm going to say the decedent, if the decedent died and was married, then the spouse is the person who must bring the claim. This often presents problems where people are separated but not divorced, or people are married, and if you're just listening to this on your computer, I'm using air quotes, are married but not legally. Because I get two calls a lot. I get the call that says my wife was killed. Okay, how long? And at some point, this is not the first thing I said, but at some point you say, how long were you and your wife married for? Oh, well, we've been together for 10 years. And when I hear something like that, my ears kind of perk up. Oh, you guys have been together, because I've had this happen where somebody says they're married. They're not doing it to trick anybody. They treat the other person as their spouse, but legally they weren't. Maybe they went and had a wedding, but didn't sign the paperwork for some reason. Who knows? So when that happens, when I hear, oh, we've been together for 10 years, I say, well, when did you actually get married? Because I need to make sure that person is the true spouse. On the flip side, if people are separated and just haven't gotten divorced, you might get a call, and this is going to happen in all these different categories. You might get a call from the parent of the deceased, and says, my son was killed. At some point you say, was your son married? And they say, yes, but we don't talk to our daughter-in-law. She lives in Arizona and they haven't spoken in 2 years. They just haven't gone around to getting divorced. Well, you know who has the right to bring a lawsuit? The person in Arizona. So that presents challenges for trying to round people up. And when I say round people up, I mean get the right people signed up as clients of yours, so that way you can bring this lawsuit. We have a case right now where our client actually died during the pendency of the lawsuit. So we filed the lawsuit, she died, and I don't want to over exaggerate here. I'll say it was 6 months, but we had to find, I think, 7 or 8 children in a 6-month span, all spread across the country, all with some combination of different parents, in this case it was different fathers. So it was very difficult to find all these people because our client was not married. And that, I guess, brings me to the next point. If you don't have a spouse, but you have children, the right to bring the claim is with your children. The right to bring your claim, the right to bring the wrongful death claim is with the children. If no children, then it's your parents. So think of it kind of going up and down. It's spouse, your children. If no children, go back up to your parents. It's kind of like a family tree. That's how I think about it in my head. People that will not ever have the claim for a wrongful death: aunts, uncles, cousins, grandparents. I get that call a lot from grandparents who say, my grandson was killed, my granddaughter was killed. They're not going to have the claim unless, here's the catch-all, unless if there is no spouse, children, parents, then the personal representative of the estate can bring the wrongful death claim. I'm going to say that again. If there is no spouse, no children, no parents, then the personal representative, the administrator, the executor of the estate, can bring the wrongful death claim, which circling back makes it even more important in certain situations why you make sure that you pick, to the extent that you can, that you help pick an executor that is going to be a very good face for the lawsuit. By the way, if you're in a situation where the personal representative either is a very poor choice or can't be appointed, and the reason somebody might not be able to be appointed to be a personal representative of an estate might be criminal history, bad credit. It could be that the person has some disability or some condition that prevents the person from doing it. In that case, you may consider, and you should consider, a professional administrator. If you need recommendations, let me know. But professional administrators are people, usually lawyers, who serve an administrator role for estates when either someone can't do it or someone doesn't want to do it. The other reason, by the way, another reason that someone might not want to be a personal representative or can't be, is because oftentimes you have to put up a bond. And if somebody doesn't have money or can't qualify for that bond, that person's not going to be able to do it. We had a case where, where somebody had to post a $5,000 bond, and we were able to help with the process. But before we got involved, those folks didn't know what to do because they couldn't come up with the $5,000 or couldn't get any sort of financing options, we'll call it, with someone who can put up a bond. All right, so takeaways. Estate claim, you need to set up the estate and have a personal representative appointed. Wrongful death claim, finding out who should bring the claim is probably the most important thing. When the person calls your office or when you hear about a case, make sure you're talking to the right person and make sure you have all of the right people. You think to yourself, oh, there's no spouse. I'm talking to the person's child. Sure. But the person has 4 children. You need the other 3. And I'll put an asterisk with the word need. You don't actually have to have, but do everything in your power to get all of the correct people in whatever level, spouse, there's only 1, children or parents, could only be 2. Make sure you do everything you can to get every person in that level, the correct level, because it's going to avoid a lot of problems down the line. And I don't have enough time to give you war stories about all the problems that come from dispersing a personal injury settlement. But I encourage you to move deliberately, slowly, and purposefully, if you win a wrongful death case, to make sure the money goes to the right people. That is maybe one of the most dangerous situations for personal injury lawyers, because once the money is made, once the money is settled, if you give it to the wrong person, that could be a huge problem. I will say very typically, broad brushstroke here, that Georgia reserves 1/3 of the settlement, 1/3 of the wrongful death settlement go to the surviving spouse, and the remainder goes to the children. So in your common situation where someone has a spouse and children, even though the spouse brings the lawsuit, at the end of the day, when the case is over, when I say the case, I mean the wrongful death case, 1/3 of the money needs to go to the spouse, the remainder needs to go to the children. That is a very broad brushstroke, very, very broad. You might be thinking to yourself, what happens with the money that goes to the estate? Well, it goes to the estate, and then the estate disperses the money as it should to, whether there's a will, maybe it's however that's supposed to happen, or if there's no will, it gets divided among the heirs. So remember, once you get the money, slow, deliberate, purposeful, and make sure you're really careful about where the money goes. All right, so we talked about the 2 different types. We've talked about how long you have to bring these claims, and we've talked about who should bring them. I'm going to jump to damages because I think that's the most important part of these cases, but also maybe the most interesting. But before I get there, I do want to just mention some pretty obvious realities in these cases. The first thing is you don't have a client who can tell his or her story. And that makes investigation of these cases very, very difficult. For example, I have a case where a client was shot in an apartment complex and killed. I don't know this person's story. I generally kind of have an idea, but I don't know what the person was doing when they were shot. I had a case where my client gets into a car crash and pulls over to the side of the road and then is hit by a truck and is killed. That person, I think by at least witness statements I've taken, was outside of his vehicle when he was killed. I don't know why he was outside of his vehicle. I can make assumptions, I can guess, I can reason and think about why and offer options, but I don't know why for sure that he was out of his vehicle. So a lot of times it makes it more difficult in the information gathering stage for you to find out what actually happened. Nevertheless, what I promise to clients, and I will always promise, because if we do our job right, we do it fully and correctly, we'll always meet this promise. I promise families that, assuming there wasn't someone with the decedent who watched everything happen, I promise that I'll find out more information than they currently know whenever I'm speaking to them, that I'll find out more information and be able to at least tell them the story. So if you have a family who doesn't believe in lawsuits, doesn't think they're right, maybe that's not important to them at the moment. I think telling that family and honestly telling them, look, during my investigation, I promised you I'll find out more things than you know today, and you'll have more information. I think that's a pretty good reason for a family to sign up a lawyer and begin the lawsuit process, even if you don't go forward with it. So I don't want to call it a selling pitch, because that's not what it is. It's a benefit to hiring a lawyer and allowing the lawyer to investigate, is that family is going to learn more about the wrongful death and the situation that happened. On the other part of, you don't have a client necessarily, you don't have the decedent there, it makes gathering information about the person's history also more difficult. And it becomes a minefield, I think, for defense lawyers to try to lay traps in interrogatories and in depositions. What I mean by that is, I've got a case where my client is the mother of the decedent. The decedent wasn't particularly close with her mother. The decedent had some drug and alcohol problems. They were close in the sense that they loved each other and talked frequently, but they hadn't lived together in a very long time. And at some points, the decedent was cut out of her mother's life. The defense has really drilled in and asked very specific things about the decedent's past, about her history. Part of that is what I'll touch on in damages, is to get to know who the decedent was, to value the life. But the other part, I think, is to try to lay a trap, so that way, if there's a answer that eventually is untrue or doesn't, or our representative doesn't know, it makes it seem like the representative doesn't know her daughter, that mom doesn't know daughter. It could make it seem, it could be interpreted that mom's not being honest or telling the truth. So for example, in this case, we were asked to name all of the times that the decedent was arrested. And with her drug and substance abuse problems, she had been arrested a good bit. We were also asked every hospital she'd ever been to. Her drug and alcohol problems were, to a large part, it seems, due to some mental health issues. So you put those two things together, and she's getting arrested a good bit of times, and she's also ending up in a lot of hospitals. Mom, personal representative, mom didn't know all the places she's been. So I'm usually one in discovery responses to just say it like it is. Here's the answer. This is one of the few times that we are very careful on how we respond to discovery, where we say, based on what we know, here's the answer, but we don't know everything. There's no way for us to know everything. We promise if we find more information, we'll tell you, but we go out of our way to make sure that we do two things. We make sure the representative is being honest and accurate, and we leave the representative wiggle room to change or modify or add to the answer. We also, though, want to make sure that we don't just say, we don't know. We want to make sure we make the representative look credible and make sure that the relationship between the mom and the daughter, or whoever it is, that's amplified as best as we can in an honest and legitimate way. It's stronger. We want to show the strong relationship. So let's put evidence collecting aside and let's talk about damages. So for the estate claim, let's just get these out of the way real quick. For the estate claim, you're going to want the funeral bills and the burial costs. You want those. If there's any medical bills, from before the death that relate to the incident, you want those as well. So somebody is in a car crash, they are transported to the hospital, and then they pass away. There's a funeral and they're buried. You need a few things. You're going to need the ambulance bill, any sort of hospital bill, all those that go into that, physician charges, radiology, whatever happened. You need all those medical bills. Then you need the funeral bill and the burial costs. So those are the three things you're going to need to know. Then there is that. I told you to put a pin in it to remember. Then there's the conscious pain and suffering. Conscious pain and suffering. And it's exactly what it sounds like. It's the pain and suffering that the person experienced and knew they were experiencing from the time that they were injured until the time that they passed away. So in this car crash example, the conscious pain and suffering would count from the time that the person was in the car crash. In fact, even before it, if the person saw it coming, an element of pain and suffering is the anticipation of shock. It's in the jury charges. I encourage you to look at the jury charges for pain and suffering. In my office, we have a big board. This is my made-up board, but we have a big board. I actually used it at my last trial. It's a list, and if you haven't seen it, email me and I'll send it to you. But it's a list of all of the non-exhaustive options, all those non-exhaustive listed things that are listed in the jury charges. And one of those is the fear of impact, of what's about to happen. So remember, pain and suffering starts from the moment you know something is going to happen to you. And I think that's really important. Okay, so it's from that moment all the way through the death. There are some very powerful arguments you can make where someone has spent the last minutes, hours, days. I've had clients in comas for months. It's a little different on a coma though, but and I'll finish the thought. It's a little different because if the person isn't experiencing the conscious, that's the key word, conscious pain and suffering, it doesn't count. But those last however long of someone's life, that's what the last thing they thought of. They were in pain. And you can make some very powerful arguments about that time in that person's life. I mean, and I don't mean to bring us all down today. I guess I am asking you to imagine this. Imagine if you're laying on the side of the road after a car crash and you know it's 2 a.m. The other driver drove away. There's no one around. There's not a street light. It's dark. And you're on the side of the road and you know you're not doing well. And you think to yourself, I'm probably going to die. I don't know if anyone has had that experience. I have not. But I can't imagine what that feels like. I can't imagine what it feels like knowing you're going to die. And I think that if we put ourselves in the mindset of our job is to sell this claim for the highest price to the highest bidder, that is an extremely powerful moment in someone's life. I have a case right now, and I won't tell you all too much because there's a demand pending and I'm usually very open, and I'll be as open as I can, but all I'll tell you about this case is that our client was dying and was being held by her daughter. And her daughter's 13 years old. So she is literally laying in her daughter's arms. Daughter is holding mom. They're on the floor, laying with each other. And mom, I'm actually gonna get teared up here talking about this because I'm so involved with the family. But mom is dying in the daughter's arms. And that conscious pain and suffering, knowing that you're going to pass away, especially in that situation, is extremely valuable. So I want you to make sure that you know if there is conscious pain and suffering. And the way to do that in a wrongful death case is a lot of times you can use common sense. The person was alive from this point to this point. But even if it's a second or two, it's worth investigating whether that person was alive, even for a second or two. Speak to the medical examiner. Ask the medical examiner, hey, the way this person died, was it on impact? I had a case once where a woman ran into the back of a tractor trailer. The question was, Did she die on impact? The answer was yes. The answer was yes. But it's worth finding out, and it's important. And if we go back to the function of being a lawyer, or not just being a lawyer, of being an investigator for a family to tell them things they don't know, although they might not want to know, maybe they should know if their loved one did suffer or didn't suffer. So that's something you might want to find out. And that's something you should undoubtedly find out because it goes to the elements of damages. All right, let's talk about the wrongful death damages. Wrongful death damages. I'm over here in my wrongful death world. Wrongful death damages are the full value of the decedent's life without any reductions for expenses or costs that they would have incurred. I felt like I said that fast. Let me say that slower. Wrongful death damages is the full value of the decedent's life from the decedent's point of view, without any deductions for the costs or expenses of their lives. So that's that last part. Let me get rid of that last part first. Without any costs or any deductions for the costs or expenses of that person's life. What that means is if you're going to say, we'll use the lost wages. There's future lost wages for the next 20 years because this person died. You don't reduce that down for taxes. You don't reduce that down by the gas that it would have taken for them to drive to work. You don't reduce that down by the food they would have spent at lunch. You don't do that. You don't deduct any expenses. You're only adding. Don't deduct, only add. So what are we adding? Well, the value of somebody's life. What is that? I don't know. And anybody who tells you they do know, they're lying to you. No one knows the value of someone's life. I can run through, and there's a whole webinar on this. It was one of the first ones, but I'll run through some ways that we can. I'm not going to leave you hanging here and just say, I don't know. Let me run through some ways that you can value someone's life. Obviously there's the per diem amount. You can say that life is worth this much a day. I'm a big fan, although I don't actually believe in the justification, but this is more of a me thing. I'm a big fan of relating the value of someone's life to work. Value of someone's life to work. It almost pains me to say that your life should be valued based on work. And what I mean is if you're willing to get up and go to work every day for $15 an hour, you make that conscious choice. I think it's fair to say that the hours you're not working is also worth $15 an hour, at least, because you're saying if you work 8 hours in a day and you have the choice to work a 9th hour, but don't, what you're saying is, I don't want to work for $15 more on this day for 1 hour. It's more valuable to me to not work. So to me, if you're not working, your time is actually more valuable than work. This gets on a bigger topic of do you work to live or live to work? We'll handle that on another day. Maybe I'll set up a couch right here. I can put on some fancy glasses and we can have a therapy session, but we'll pause on that one for now. So you are going to need to come up with a way to value the life. One way is the per diem, to say, this person went to work and it was this value, so you should add that value. It's X dollars for working, so 8 hours a day. Well, there's 2 times that. There's 16 more hours left in the day. So what we'll do is we'll do 2 times the amount of money this person made per day, and that's what we'll do. Other ways, especially when somebody isn't working or doesn't have a good job, or maybe has and I don't mean it doesn't have a good job, I mean doesn't make a lot of money per hour, or maybe the other extent makes a ton of money per hour, which can cause problems, especially in certain venues. You need to find other ways and be as creative as possible. It's time tested, but it's also pretty boring to me to say, cars and paintings and other crap is worth millions and hundreds of millions of dollars. If you feel comfortable with that, it kind of like, that gives me pause, because it's almost like saying to the jury that this case is a house of cards. And that just makes me want to pull my hair out, because I think you can come up with something that's more persuasive for the jury than something that is kind of overplayed and done and doesn't really convey, I think, what you're trying to say. We called somebody the Bill Gates of grandmas. So we said, you know, this woman was done working. She was in the prime of her life, the golden years where she spent all this time working and taking care of a family. And that was about her. Thankfully, what she wanted to do with her life was spend time with her family. So we called her the Bill Gates of grandmas. And I think that was pretty powerful. So what you want to do in a very technical way is sit around, get a glass of wine or whatever you drink, or just relax and think to yourself, how can I relate the value of this person to the jury? And that may just mean looking inside yourself and asking yourself how you value your own life. You know, we can't ask because of the golden rule. We can't tell the jury to put themselves in the shoes of the decedent or the injured person about damages. Note, you can ask the jury to put themselves in the shoes of the person for liability purposes, for negligence purposes. Fun fact, you can't do it for damages. But I think that part of the exercise of figuring out how you're going to value someone's life is looking into yourself and saying, how do I value my life? And then next step is trying to channel that person that's passed away and ask to yourself, if I was that person, what would I value my life at? So I think it's an interesting exercise that I think will help you. It seems touchy-feely and kind of strange, but next time you have some alone time, think about that. It might not put you in the best mood though, but think about that. It may also lead you to some other inner discoveries about what's important in your life. So anyway, get off my soapbox there. The other element of damages that I think is pretty important, that is very important, is future lost wages. Future lost wages. Here's my disclaimer on future lost wages. It's not just wages. I'll say that again. It's not just wages. It's total compensation. When you go and you want a new job, I mean, when we hire people, the questions we get asked are, what's the salary? Okay, those are the wages. Do you offer health insurance? Do you offer dental? Is there a retirement or savings plan of some sort? Do I have to pay for my parking? Do you pay for lunches at all? Will you pay my cell phone bill? Those are all questions I get asked. And our answers are yes, by the way, but that's adding to the compensation. So when you think about lost wages, if someone's working, make sure that you factor in total compensation. Is there disability insurance? Is there life insurance? So what you want to do is you want to contact the HR department and you want to get the entire compensation package. So that way you can go and hire an expert to calculate the total lost damages. You want an economist. But lost wages are not the only element of damages that you can quantify into money using an economist. You also need to factor in the amount of household services that person does, whether they work or not. You know, we make a choice in our lives to do our own laundry because hiring somebody to do our laundry, I'm using easy numbers here, fake numbers, would cost $20. It's worth my time to do that. So to me, it's worth at least $20 to not pay someone for me to do it. And that's true with yard work, household cleaning, transporting children. I mean, all that stuff that you do, that is valuable. That is valuable. I mean, you know, I won't get into the whole stay-at-home parent, whether that's a job or not. In the legal sense, though, in a wrongful death case, I don't know if it's a job or not. It's a valuable service that needs to be compensated for. So all those things that the person does, whether they work or not, all those services that they perform, everything from loading the dishwasher to transporting children to, you know, online shopping for Christmas, literally everything, that can all be quantified. So the value of someone's future lost wages or future lost value in financial terms is their total job compensation, as well as the entire amount of the household services and other services they provide to the family and that they have to do for themselves. Okay. Hopefully that makes sense. If it doesn't, let me know, because it's a very important topic. Because you're essentially able to quantify and put a value on every hour of the person's life, except when they're sleeping, through this way. You're able to put it through their work time and their non-work time, through their work time and their non-work time. and that can drastically increase your award. Something I like to do, if you have a case where you're saying to yourself, I really want to send a pre-suit demand, the insurance company or whoever you're dealing with, defense lawyer, says they want me to quantify lost wages. And I don't know how to do that. I don't want to go and hire an expert for whatever reason right away. Maybe the limits aren't high enough, but I need to touch on this area. What I encourage you to do, depending on the age of the person, so the younger the person is, the more that this way is going to be better for your case. It's going to be more persuasive, is just take minimum wage. Take minimum wage and say, look, if this person worked 40 hours a week for up until they're 60, 65, whatever number you want to use, they would make, and even if they only made minimum wage, this is how much that calculation is going to be, 40 hours times 52 weeks times however many years. That's how much this is going to be. And then also assign minimum wage to their non-working time, assuming that they sleep 8 hours, which if you know anybody who sleeps 8 hours, please let me know, who's not a child. That's one way to kind of do a little cheat sheet, and it's supported by reason and logic, but it's also less expensive. If your case doesn't support it, it gives you a way to present lost wages and lost monetary value in other household services without having to hire an expert. So those were the main things that I wanted to talk to you all about. I'm going to open it up for any questions here. If anybody has any. I've jumped around. I'm going to take a quick look at my notes and make sure we haven't missed anything that I thought was really important here. Damages on a wrongful death case is also is a difficult conversation that you need to have with the family, because I had a case once where a client refused to let me ask for anything less than $1 billion with a B, $1 billion. And he refused for about a year. His wife was killed and he wanted to ask for $1 billion. And I mean, shit, who was I to tell him that his wife wasn't worth $1 billion? I mean, I guess I'm the lawyer he hired, and that was the actual answer. What I ended up doing, just for a little war story here, what I ended up doing was hiring a focus group. And I had him sit in the focus group. I introduced him, but didn't say what his relationship was to the case was. And that way he was able to hear from other people. And I explained to him that, asking for $1 billion, I thought would hurt the recovery. So what I did in in the closing was I told the jury, my client thinks that his wife, that you should award $1 billion. And I don't disagree with him. But in the legal sense in Georgia, at this moment, I'm not going to ask you to award $1 billion because I don't think that's the value that you should give in this context. So that was a challenge. That was probably one of the only times that I had a pretty strong disagreement with a client about what I was going to ask for, because for a long time, literally leading up to trial, to the point where I got very concerned I might have to withdraw, the client, right? Not that I have to withdraw, that I could withdraw. The client refused to even let me entertain another number and tell that to the jury. And the reason I tell this story is because we don't have the right answer, a perfect answer to tell the jury what someone's life is worth. I am of the belief that when you are asking for a verdict for an award, especially in a wrongful death case, that you have, I'm trying to think the best way to say this, you have protection, because no one in their right mind can be mad at you for asking for too much money for the value of someone who lived, so long as they are not murderer, child molester, some terrible, terrible person. And if they are, gently suggest that you don't represent them, because it's probably not going to go well for you in your case. I had a case once where a child molester was killed and that person's family wanted us to represent them. They had a valid claim. It just wasn't something that we were prepared to do and felt comfortable doing. That person under the law has the right, or that family has the right to bring that claim. And we helped them find somebody, but it wasn't up our alley. And part of the reason was I didn't feel comfortable with it. But absent some crazy situation like that, you can stand up and say this life was worth $100 million. And you can say that without blushing, because who the hell is the defense to say this life isn't worth that? And using the kind of cliched ones I mentioned that I'm not a fan of, I'll use them right here though. Why the heck is I don't know, some crazy painting worth $100 million, but we can't say a person's life is? That defies logic. So I think it's important to not be afraid to ask for a large number. Don't be afraid to ask for a large number in a wrongful death case, because I think you have some coverage. You have some outs, as opposed to a case where you have $50,000 in bills and you ask for $5 million and that person's alive. You might have a problem. The jury is going to say, hey, that injury isn't worth that amount of money, assuming there's not some absurd, crazy permanent injury. All right, the last thing I want to leave you with, in the spirit of this being the last webinar, in the spirit of this year, in the spirit of the holidays, and also in the spirit of hopefully giving you some sort of parting word, something that's crossed my mind as I was preparing for this. One way that we tried to promote this event, which we'd never done before, is to give back. So for everybody who joined this webinar, and there's a good list of folks, we're going to donate $20 $20 for each person. And in fact, I'll double it today because I think that's really important. We're going to donate $40 per person for everybody that was on this webinar, including me. I'm on this webinar, to the Atlanta Community Food Bank. That's a charity that an organization that our team has volunteered at the food bank. If you haven't done that, it's a really rewarding experience, and it's really interesting. It's really cool. So whether you're, I guess what I'll pause and say is, if you don't have a charity, if you don't have an organization that you're passionate about, I think it's worth your while to find one. I think it'll be valuable, and it can be used in a personal worth situation, as well as it can be used to motivate people to do things that will help you. I've motivated people to join this webinar by the idea that we'll donate, for every person that joins. Being in the world that we are in, I will say, and I'll say until I die, money is, our sense of money is warped. Our sense of money for personal injury lawyers is extremely warped. In my office the other day, I was walking down the hallway and I heard this phrase, literally, well, I don't know if we can settle. They're only offering $100,000. I shrugged and kept walking, didn't even think twice. But preparing for this webinar, I thought about that moment. Just the idea that it's only $100,000. And in my office, we've said things like, I have a case right now that I said, I'm not settling for $2 million. That's not enough. In any other context in the world, in almost any other context, saying something like that will get you looked at like you're a crazy person and probably a jerk. Our sense of money is extremely warped because the numbers are oftentimes very high. They're warranted, but the numbers that we deal with, the whole numbers, are very high, and you forget that, at least I do, I'll speak for myself, you forget that $25,000, $50,000, $100,000 could be life-changing to people. With that said, there's also a lot of people out there, and a lot of us have clients like this, that are hoping for money or don't have any money. And for those people, I think it's our role as a lawyer, as a counselor, as a human, and as somebody who cares about the community that you live in, to do something this season to help somebody. So that's what I'll leave you with here. Find a way for you to give. Talk to if you're a business person and that's kind of who you are and that's your makeup, go talk to your CPA and say, hey, it's coming up on the end of the year. Can I donate somewhere to get tax write-off? Do the Georgia Goals, which is you can donate to a high school here in Georgia, or and get a tax credit of sorts. You can donate to a rural hospital in Georgia and get a tax credit of sorts. You can do a whole bunch of things. You can buy tax credits for through the film industry to promote business in Georgia. You can do all that for taxes. Might be more rewarding though to find something like the Atlanta Community Food Bank, like some sort of organization that helps individual people in our community, whatever community that is for you. I see some people from outside of Atlanta and even outside of Georgia. So find something in your community, give back, encourage your folks to give back, and lead by example, not only for the people that you interact with, but hopefully for our world as a whole. This is the last, like I mentioned, this is the last webinar for 2021. I wish you, I wish your family, and I wish everybody that's close to you a healthy, a happy, and a hopefully joy-filled holiday season. If I don't talk to you before 2022, please know that I wish you the best, and I appreciate y'all joining me. The link for 2022's first webinar is in the chat. I don't have a topic yet. I haven't even started thinking about Christmas, as you know, based on my lack of Christmas shopping that I mentioned. So I don't have a topic yet for 2022, but it'll be the first Thursday of 22, which I think is the, let's see, it's the 6th, the 7th, I want to say. It is the 6th, so it'll be 9:30 on the 6th. We've also been sending out, I've been sending out a survey as well about these webinars. If you get the survey, which you will because you're on this webinar, please respond back. Help me help you. Help me find interesting topics. Help me talk about the things you want me to talk about, and help me do it at the right time, in the right place, and the right method, so it conveys the best information for you. My phone number and my email are in the chat. Reach out to me anytime. I enjoy meeting people I don't know. So if you're on this list and we haven't met personally, I'm pointing to my participants list. If you're on the list and we haven't met personally, reach out. I'd love to hear from you. And I wish you all the best. Okay. Be careful for the elf on the shelf. That thing will get you. Bye, everybody.